Hello, today is Thursday, October 9th, 2025. I'm Tony Mangino from TC2, and this is Staying Connected. I'm joined today by Laura McDonald, a partner at LB3, to give us an update on legal developments that impact the use of AI in contact centers. Laura joined me about a year ago to discuss legal developments that could impact the use of AI in contact centers, and I invited her back today to ask her whether there have been changes in the legal landscape that enterprises should know about. Laura, thanks for coming back.
Tony, thanks for having me. It's always a pleasure to join you on Staying Connected. And you're right, almost exactly a year ago, we talked about the efficiencies and advantages that AI brings to the contact center. And as often the case, we also talked about how the technology was ahead of the legal framework, which creates uncertainties and opportunities for disputes. And frankly, on that front, little has changed, but I'm happy to give you a quick update on what I'm seeing today.
Laura, can you start by giving us a quick refresh on how AI is being used by enterprises in contact centers?
Absolutely. And it's exciting. AI is making a big impact, both for efficiencies and ultimately cost and customer satisfaction, which is a key component of your contact centers. Various companies have cloud based solutions that make the agent and client process more efficient. For example, AI allows agents to access information and assess customer questions in real time. It helps route inquiries to the right agents based on the content in the question. It allows the contact center agents to better identify issues at hand. It reduces wait time, which then reduces agent and customer frustrations. It can also provide automated, intelligent responses and information without the need of live intervention. And frankly, the list goes on. It's being used to make real time transcriptions, identify trends. It can be used to authenticate calls, to deter fraud. By using AI for real time sentiment analysis, agents can respond more artfully to customer concerns and determine if some issue needs to be escalated or transferred. And it also allows AI to address the more routine issues, which frees up agents to deal with the more complex ones. So there's a lot.
That all sounds great, but what's the catch? Are there potential pitfalls that enterprises need to watch out for?
Well, Tony, any technology migration has risk, and companies often focus on the transition and the operational risk, but we also need to think about the potential legal risk. And it's, of course, easier if a product and the laws that govern it are time tested and true. But that's not the case in the use of AI, at least right now with contact centers. So enterprises have to anticipate, they have to understand and manage potential legal risk and what's a gray area. And that's harder.
Wait a minute, there are no laws in the US governing the use of AI in contact centers?
Yes and no. A good lawyer answer. Legislation in the US directly addressing AI is still in its infancy, but the lack of comprehensive and specific AI legislation in the US does not mean that everything's fair game with regard to contact centers. Whenever there are no specific rules, companies, litigants, and judges look to see what's already in place that might apply. For example, there are laws that impact contact centers, for example, governing recording calls, privacy, consent. There are things like the California Invasion of Privacy Act, CIPA, the Federal Wiretap Act, HIPAA for health data, the Illinois Biometric Information Privacy Act, BIPA, and plaintiffs' lawyers are creative. And even if these weren't written with AI in mind or AI in contact centers specifically, plaintiffs are able to apply them to contact center solutions. In addition, there are basic legal premises, sometimes referred to as common law, that create obligations and rights, such as the implied or actual contracts or liability based on negligent acts. A litigant might claim that your AI agent created a contract promising benefits that you never intended to promise, or that they were harmed by the negligent actions of your AI agent, say by providing incorrect directions that led to an injury.
Are you seeing litigation involving the use of AI in a contact center environment?
Yes, and I would lump them into two categories, really. One is that the AI platforms are hallucinating or providing misleading information, like the Air Canada case that we spoke about last year that gave bad information to a customer and ended up very poorly for Air Canada, or claims that the use of AI technology to authenticate callers or to intercept or record or respond violated the customer's privacy or other state laws. Basically, instances where the customer claims they had inadequate notice and or did not provide or have the opportunity to provide appropriate consent.
Laura, can you give us a few real life examples here?
Sure. I mentioned BIPA and SIPA, and those are example of statutes that are in the book that were not specifically written to address AI in the contact centers, but they're being used in plaintiff's case regardless. For example, there was a case filed in Illinois involving BIPA claiming that John Hancock's call center's use of Amazon Connect and pin drops biometric voice print for authentication was unlawful. And then there was another complaint filed against Nuance based on Charles Schwab's use of BIPA. Now, both those cases have been dismissed based on the particular facts and status of the defender and use in financial transactions, but they provide an example of a law that might be used in other contexts for AI-centered usages. And then, on the other hand, there are a number of cases filed in California, primarily using SIPA, such as one against Genesis involving a crisis hotline, claiming that Genesis Cloud CX overhears and collects private details from callers, records their conversation, and uses that information, all those things that people want to do to be helpful for the efficiencies, and that Genesis used that information to train its own systems to improve Genesis services. And this was done without the proper notification and obtaining appropriate consent in that case. And that's based on both the federal wiretap and SIPA. The Genesis filed a motion to dismiss in that. That's going to be heard later this month.
Laura, it sounds like there's a lot to think about here. What do you recommend for enterprise customers who are considering taking advantage of AI as part of their call centers?
Great question. Really, I would group things into three categories: knowledge, protection, and a plan B. For knowledge, as a just a generic matter, map out every AI application in use in your contact center. Know what type of data is collected, where it's stored, how it's shared, by whom, where, and how. Know how sensitive that data is. Is it used only within your enterprise, or is it helping train broader models, such as those of the CX provider or its agents? Make sure you keep abreast of what's happening there. And then, generally, in the protection side of things, build robust contracts that clarify those aspects, the data usage and protections with your vendors. Know if there's any involved third parties and have protections for those as well. And then make sure you're obtaining explicit customer consent and keep thorough records. The one size fits all consent banners or scripts are not enough. You need to be specific about what data is collected and how it's used. And you also have to be sure to monitor responses so that if your AI solution is hallucinating or creating potential contracts that you don't want, you can catch it and resolve those issues quickly. You may also want to consider ways that you can add clear and visible caveats that provide information as to the benefits you're not offering, or saying to finalize any of these things, you need to talk to a real agent or look at your contract. So there's some things you could do on the protection side as well. As far as plan B, if a customer declines consent and you need to make that an option, you need to know what your alternative is. Can they interact without the AI solution? And you need to spell that out. What happens if someone opts out? Your agent should know what they need to do. You need to make sure the end user knows that that is an option, and you have to honor it. And then, unfortunately, that does mean that some of the efficiencies that you would want to use AI for, you lose, but you may save that in either avoiding litigation or having an easier defense to litigation.
That's a great point. Laura, in your experience, what can a company do to keep up in this fast moving legal and technical environment?
The best prepared companies have pulled together a team, and that consists of legal, compliance, IT, and ethics. And they would need to work together to review and assess things during the procurement stage, during the contracting stage, during the rollout stage, and then thereafter. And they need to be proactive. Companies need to be proactive, and they need to review technology changes. They need to keep an eye out for lawsuits and developments in legislation, and they need to be able to adapt as new information comes out or as features and functionalities change. If it's a high risk area or information, those absolutely have to be vetted. In addition, you need to ensure that agents and support staff know how the AI works, what its limitations are, and how to respond if there's a customer concern. And you need to update your interactive voice response and chatbot scripts as features, litigation, and laws evolve. Because what protects you last year or protects you today is not necessarily going to protect you tomorrow. In short, your compliance reviews need to be ongoing.
It sounds like companies should take advantage of AI, but should do so thoughtfully. No one wants to spend money on fighting a class action, that's for sure.
Absolutely spot on. But being careful doesn't provide you with a risk free experience, but it does mitigate the risk. And, as a lawyer, we're all about mitigating risk.
Laura, thanks for the update today. It's always great to have you on Staying Connected. If you have any questions or if you'd like to learn more about how to mitigate the legal risks of AI associated with CCaaS solutions, or you'd like to discuss best practice for sourcing CCaaS, please contact Laura, me, or any of our LB3 and TC2 colleagues by giving us a call or shooting us an email. You can also stay current by subscribing to Staying Connected, by checking out our websites, and finally, I'd strongly recommend that you take a minute to go ahead and begin following us on LinkedIn.